Hello everybody, welcome to the lecture series on intellectual property. Today's class would be focused on intellectual property and intellectual property rights. So the outline goes like this. We will know what is intellectual property. Intellectual property means intangible property that is a result of creativity such as patents, copyrights, etc. Then intellectual property rights. These are the rights given to persons over the creations of their minds that usually give the creator an exclusive right over the use of his or her creation for a certain period of time. And IP protection tools. These protect inventions and improvements to existing inventions. Now, what do you mean by intellectual property? There are three major types of intellectual property. Number one is patents. Number two is copyright. Number three is trademark. Patents Act happened in 1970 and it was amended in 1999, 2005, 2016, 2018 and 2019. Patents Act mainly deals with functional and technical inventions. Then comes Copyright Act of 1957. It was amended in 1982, 1984, 1992, 1994, 1999, 2010, 2012 and 2019. Copyright mainly deals with purely artistic works. Then comes Trademark Act of 1999. It was amended in 2002, 2010, 2013, 2014, 2017, 2018. Trademark deals with symbol, logo, word, sound, color, design, etc. Here we can see there are three persons sitting and one person is asking the question, can I patent my copyrighted trademark? The other person, as shown in the figure, seems to be hopeless. What do you think? Do you think the statement is correct? If you don't see problem with this question, then definitely you need this class of intellectual property. So let's go ahead. As mentioned in the outline, an intellectual property is an intangible asset. So what do you mean by an intangible asset? An intangible asset is an asset that lacks physical substance. It basically results from creative efforts of human intellect. So, in contrast to physical assets such as machinery, buildings, financial assets such as government securities, an intangible asset is usually very hard to evaluate. Such creations cannot be materially measured. So, some of the examples of intangible assets are patents, copyrights, franchises, goodwill, trademarks and trademarks. Let us understand what business assets are all about. A business asset is an item of value owned by a company. Business assets span many categories. They can be either tangible assets or intellectual property. Under tangible assets, we can have buildings, we can have machinery, we can have real estate, we can have computers, office furniture and other fixtures, infrastructure. And under intellectual property, we can have intangible items which are known as know-how, human resources, business relationships, brands, etc. There are three types of intellectual property. One is soft IP, the second one is copyright and related rights, the third one is industrial property. Soft IP relates to secrets, know-how and confidentiality. Copyright and related rights relate to literary and artistic works, related rights and databases, and industrial property relates to trademarks, patents, industrial designs and so on. We would be studying in details about the soft IP, copyright and industrial property in later lectures. Let us now understand what soft IP is all about. Soft IPs are intellectual assets which are not included in industrial property or in literary and artistic works but have an important value for organizations. The different soft IP components are know-how, trade secret, confidential information. Protection of soft IP is done by the following methods. They are not protected by registration and specific IP legislation. They fall under the category of intangible rights associated with other IPR. They are free of charge and they do not involve long or complex registration processes but require internal management. Which are the IP protection tools that are available? Let us have a look at it. Industrial property generally protects inventions from the industry or from e-commerce or commerce, and they can take the form of patents, industrial design, trademarks, and so on. Now, what is a patent? A patent is a title providing the inventor and or the applicant with the exclusive right to prevent others from possessing, using, selling, manufacturing and importing the patented invention or offering to do any of these things within a definite geographical area. What can you patent? Patents may be granted for any invention concerned with the functional and technical aspects of products and processes. To qualify for patent protection, the invention must fulfill the so-called conditions of patentability. Number 1 is novelty. Number 2 is inventive step, which is non-obviousness. Number 3 is industrial applicability or utility. And number 4 is patentable subject matter. How to apply for a patent? Here we are going to look into the patent application types. You can have a national patent, you can have European patent, you can also have international patent. For a national patent, you have to apply your patent to the National Patent Office. You have to fill up the application form of national patent and then submit it to NPO. If you want to have European patent, there has to be one single application in one official language. You can either submit it to your NPO or at EPO, that is European Patent Office. European Patent Office grants patents having the effect of a national patent in designated countries. For international patent, you have to file an international application form, and patent protection can be obtained in each designated states between 133 worldwide. PCT applications may be submitted to your NPO or to the EPO or to the WIPO, World Intellectual Protection Organization. Now, duration of protection of patent is 20 years without renewal. Now let me explain to you the various patents that have changed the world. I'm going to discuss here 10 patent examples. Magnetic levitation maglev, patent name is electromagnetic inductive suspension and stabilization system for a ground vehicle. iPhone, patent name is electronic device. Motorized exoskeleton, patent name is locomotion assisting device and method. Quadcopter drone, patent name is omnidirectional vertical lift helicopter drone. 3D printer, patent name is apparatus for production of three-dimensional objects by stereolithography. Bionic eye, patent name is retinal processes and method of manufacturing a retinal processes. GPS or global positioning system, patent name is navigation system using satellites and passive ranging techniques. Brain implant, patent name is three-dimensional electrode device. CRISPR, gene editing, patent name is CRISPR, Cas systems and methods for altering expression of gene products. Graphene, patent name is nanoscale graphene plates. Bluetooth, patent name is peer-to-peer information exchange for mobile communications devices. Self-driving car, patent name is vision system for an autonomous vehicle. Solar panel, patent name is apparatus for utilizing solar radiant energy. 3G or third generation wireless mobile telecommunications, patent name is mobile internet access. Last but not the least, virtual reality, patent name is virtual reality generator for displaying abstract information. So from these examples, you can get an idea of what products can be patented and what may not be patented. I am showing you here two patent examples. Number one is paperclip. It happened on January 13th, 1942 by James H. Comley. You can see here the diagram of paperclip that he sent to the patent office. And the second one is the safety pin that happened on November 18th, 1958 by W. Green. Both these examples show that paperclip and safety pin that we use very often were patented long back. What is a utility model? A utility model is a title of protection for certain inventions such as inventions in the mechanical field. Utility models are usually sought for technically less complex inventions or for inventions that have a short commercial life and normally do not meet the patentability criteria. The requirements for acquiring a utility model are less stringent than for patents, while the novelty requirement must always be met. That of inventive step or non-obviousness may be much less or even absent altogether. In the European countries, only 17 countries provide registration process. The latter is often significantly simpler and faster, taking on average 6 months. Finally, utility models are much cheaper to obtain and to maintain. Duration of protection of utility models lie between 6 and 10 years without renewal. Now let us come to industrial design. What is an industrial design? An industrial design refers to the right granted in many countries to protect the original, ornamental and non-functional features of a product that result from design activity. The right concerns merely the appearance of a product, not the product itself. It allows the owners to exclude others from making, importing, selling, hiring or offering articles for sale in which the design is embodied. What can you protect by the industrial design? It may be granted for visual features of a product, that is, shape, ornamentation, pattern, configuration, etc. Designs that are dictated solely by the article's function are excluded from protection. To qualify for protection, the design must show novelty and individual character. How to register your design? You can file for national design, you can even file for European design, and you can file for international design. For national design, an application must be filled before your National Intellectual Property Office or NIPO. For European design, one single application in one official language may be filled at the Office for the Harmonization of the Internal Market OHIM in Spain. A CRD is legally enforceable and enjoy uniform protection throughout the territory of the European Union. For international design, you have to file an international application to WIPO in Geneva, and you may be able to obtain the protection in several states that are members of the Hague system. The duration of protection for a design is up to 25 years without renewal. What is a trademark? A trademark is a sign or a combination of signs used in the trade to identify and distinguish the goods or services of one enterprise from those of another. A trademark owner is granted exclusive rights to use a mark in relation to the good or services with respect to which it is registered, prevent others from using a substantially identical or deceptively similar mark in relation to the goods or services registered by the mark. Now, what can you protect by a trademark? We can protect words, letters, numerals, pictures, shapes, and colors, as well as any combination of the above. It is now allowed for the registration of less traditional forms of trademark such as 3D signs like the Coca-Cola bottle, audible signs like sounds, Nokia jingle, or olfactory signs like smells such as perfumes. Trademarks normally perform four main functions. They are: number one, distinguishing the products or services of one enterprise from those of other enterprises. Number two, referring to a particular enterprise which offers the products or services on the market. Number three, referring to a particular quality of the product or service for which it is used. And number four, promoting the marketing and sale of products and the marketing and rendering of services. There are certain requirements for trademark. In order for a sign to be eligible for a trademark protection, it must be distinctive, not be deceptive, not be descriptive, not belong to the exclusions provided by the law, be in conformity with public order and morality. How do we register a trademark? Just like patent, we can have national trademark, we can have European trademark, we can also have international trademark. For national trademark, we have to give applications before the National Trademark Office registrations, and they can be cancelled if the holder is not using a mark. For European trademark, we have to use a single application in one official language. We have to fill it up and send it to the OHIM, which is also called the Office for the Harmonization of the Internal Market in Spain. The CTM is legally enforceable and enjoys uniform protection throughout the territory of the European Union. For international trademark, you have to fill an international application. Trademark protection can be obtained in each state member of the Madrid system designated by the applicant. Applications may be submitted to your National Trademark Office or to the OHIM or to the WIPO. These are some of the trademark examples. Symbol: the McDonald's golden arc is a classic example of a symbol trademark. Catchphrases: a catchphrase that is identifiable to a person or company that is used to sell merchandise can be trademarked. Donald Trump's "You are fired" is a perfect example of a trademark catchphrase. Figure or mascot: a classic example of a trademark character is Vico's talking gecko. Lyrics: the songwriter's lyrics are trademarks. Bob Seger's "Like a Rock" was a trademark for the lyrics. Name: Coco Chanel is a perfect example of a name that is a trademark. Now let us see what priority date is all about. If you have made a second filing, that too within 6 months for a design or trademark and 1 year for a patent, in either another country party of the Paris Convention or with an international authority such as the OHIM, called the Office for Harmonization in the Internal Market, or EPO, that is European Patent Office, or WIPO, World Intellectual Property Organization, you are eligible to claim a priority date. This is important because you would want to be the first to have filed for protection. Let us now see what copyright is all about. Copyright does not protect the ideas themselves, but only the form of expression of ideas represented in a physical embodiment. The creativity protected is the originality in the choice in the arrangement of words, musical notes, colors, and shapes. This is an example of a copyright notice in hard copy. It says, Eastlink has received notice that your internet service may have been used to illegally download or share copyrighted material. This message is being forwarded to you in accordance with Canada's copyright legislation. Let us see another software copyright notice. The law says that it is illegal to make or distribute copies of copyrighted material, including software, without authorization. If you pirate software, you may face not only a civil suit, but also criminal fines of up to $250,000 and jail terms of up to 5 years. So what is a copyright? Copyright relates to literary and artistic creations such as poems, novels, music and paintings, but also includes cinematographic works, architectural works, sculptures, TV and radio broadcasts, and many others. What can be protected by a copyright? Copyright protects only the expression of ideas as long as it is original. A work is original when it is created independently and skill, labor, judgment are applied to it. Do I need to apply for a copyright protection? There is no formal registration process required in order to obtain protection. The Copyright Office, in its endeavor to facilitate seamless registration of works, has introduced the provision to upload subcopies of literary or dramatic and artistic works. Copyright protection arises automatically on creation of the work, provided it is original. The term of copyright depends on the type of work that is protected, when it was made, and whether it was published. Generally, protection lasts for 70 years after the death of the creator. What are the rights that I will receive for copyright? Copyright owners can prohibit or authorize that their works be copied or reproduced in various forms, distributed to the public in copy format, performed in public, broadcasted and used online, translated into other languages, adapted such as novel into screenplay. Mostly there are two types of limitations to copyright. One is free use and the other one is non-voluntary licenses. These are some of the copyright examples: musical works and accompanying words, literary works, dramatic works, audiovisual works, two-dimensional and three-dimensional works of fine graphic and applied art, photographs and prints, globes, maps, charts, and works of architectural expression, including drawings, technical plans and models, entire building, useful form of protection for our most coveted architectural masterpieces. Here we have come to the end of the first introductory lecture on intellectual property and intellectual property rights. We have covered areas of patents, copyrights and trademarks, and have understood what intangible assets are and what is soft IP. So thank you very much. If you have any queries, you can email me at this email address